happy Friday. Yeah. Well, hey, Ashley. I actually owe you a call, Ashley. We got some news today. I don't know if you got it yet. We'll talk later, which is good. Let's see. A couple more people still loading in. Hey, Jim. Nice to see you. So first of all, today's Friday. You know, we did some scheduling last week because we had the NJEA conference for the teachers, which meant that all the kids were home on Thursday and Friday. And, you know, they call that New Jersey Disney. I did not go to New Jersey Disney, but I did go to Gettysburg. And it was my first time driving an RV, a motorhome to Gettysburg. And that was a trip. And I did not take down any telephone poles, which is really good. So I'm very proud of myself. But thank you for adjusting your schedule and showing up this week. I really appreciate it. And we also, thank you to all the veterans. Yesterday was Veterans Day. So for all those veterans that are online with us today, and any of you who have family members serving in the military, thank you so much. We really do appreciate it. I know these are challenging times for those in the service and those who have served in the service, but thank you again. Today, we're going to be talking about commercial use. And is it still prohibited? Is it the same thing that it was yesterday? Is it the same thing that it was pre-COVID? Have things changed? Where have we gone? And where do we think we're going with it? Before we get into this, I have the preliminary announcements that most of you know already. I think Roz has them memorized by heart. But this is a general informational session. It's general information purposes only. It's not legal advice. This does not constitute an attorney-client relationship. And if you need an attorney, you have to go out and hire one and sign a fee agreement. The other thing is we will not keep anything confidential. So if you tell us all your secrets, we will be happy to tell them to everyone else. But thank you again for attending. If you have good secrets, you can talk to us offline and we will tell them to other people without using your name. So it's always interesting to keep us from getting bored. That being said, I did not put a dog of the day on the agenda, but we do have a dog of the day. I didn't realize it. Bonnie Hendricks from EPM sent her dog in, I think a corgi maybe. There you go, puppy. Right? And that's Henry. And Bonnie is from Executive Property Management. And I believe it was either his mother or older brother, Willie.
I think it was the brother, Willie.
Okay, we did have the brother, I guess, Willie on before, but so that's Henry. Henry is very cute and I like the sweater. So very nice there, Henry. Thanks for sending that in, Bonnie. And we're just going to jump right into it. So what does residential purposes only mean? What does that mean? So the challenge here is we do have to, oh, hey, Marcos, nice seeing you. The challenge here is we do have to look at the language because lawyers who drafted these governing documents, whether it's a declaration of restrictions or a master deed, use different language. So some of them say the association units shall be used for residential purposes only. Others say there shall be no commercial activity permitted in the units. And sometimes the interpretation in some of the court decisions, it actually turns on the specific language. So you have to be careful, right? And you may, if you have weak language in your governing documents, you may want to consider amending the master deed or declaration to address that because things are changing. So where are we seeing things go? So the first bullet point, and by the way, Mike Palulak is here with us today. Eileen Gambino, my office manager, is here as well. And Mike is going to be talking a little bit about some interesting legislation that went up, worked its way through the legislature, and then just got shot down by the governor the other day. So he's going to talk about that at the end. So the first bullet point is $1 of business. That's how judges used to interpret restrictions to residential purposes only. So the courts would look at the unit owner's conduct. That was the analysis, the unit owner's conduct or the resident's conduct. As our society evolved and more people started working from home, this was all pre-COVID, started working from home, people were working on the internet, people were working on computers, started out with people like stockbrokers and things like that. The court decisions moved to what's called a community impact standard. So rather than the courts looking at what the unit owner actually did, right? They would say $1 of money means you're conducting business, therefore we're going to strike down that activity. Okay, that was the unit owner conduct standard. They moved to the community impact standard, which involved a case-by-case analysis and a very fact-sensitive analysis of how this impact your residents, right? How it impact the rest of your community. And here are some examples of cases that we've dealt with, cases that we have touched on, and some of the cases that we have just been involved with citing the judge's decisions. Music lessons were always a big one. Music lessons. Adult daycare recently has come up where people are having elderly people cared for in their homes. B&B is a big one, especially for those people who are in shore regions, right, seashore regions, or even getting into the Airbnb things in areas like the Gold Coast, Jersey City, West New York, areas like that. eBay and Facebook transactions. So it's very easy to conduct business out of a unit via something like Facebook Marketplace or eBay or a platform like that. What are some of the community impacts that the courts will look at? Number one, traffic, right? Are there trucks coming and going all day? What do you see? FedEx, UPS, Amazon, etc. Is it impacting your roads? Is it impacting your safety? Is it impacting your traffic? Are the trucks impacting your roads themselves? Is there noise, right? Is there noise? This goes to like a nuisance analysis. Is there noise? Are there smells? So we've been involved in cases where a business was being conducted out of the garage. It was a wood shop, a craftsman's wood shop, and he was building kitchen cabinets, and whatever varnish or paint or whatever he was using smelled really bad, and it really annoyed people. And so smell was a big factor in that one. The other thing is, what about generating trash? How much trash is being put out? So boxes, wrapping, plastic, recycling. Many of you are not in high rises, but this can be a big issue in high rises. How much trash is being generated? How are the dumpsters being used, right? Because you remember now that where these businesses may have been on commercial sites in the past, now we're looking at post-COVID, where people may be moving to the home and they're generating substantially more trash that would have wound up in the office building's dumpster, and now it's winding up in your dumpster or your trash chute or your trash room, right? And you may see your tipping fees increase because of that. On the high-rise side, again, many high-rises have a box handling room where there is a concierge or assistant concierge who handles packages. Is that impacting your staffing of your high-rise building? Because FedEx, Amazon, et cetera, is coming and going and coming and going, coming and going, and your personnel is being overtaxed there. And I've been in high-rise, some of our clients in Jersey City, where the package room is basically stacked to the ceiling and they're pouring out over the stairways because so many boxes are there with so many people working from home. So where my belief is right now in New Jersey, although there's not a case 100% on point, that a court would apply the community impact standard to the definition of residential purposes only restriction, right? So you would have to go through the analysis. The trouble is, and you'll be shocked by this, sometimes association board members can't distinguish between the two standards, the unit owner conduct, $1 of business, and the community impact standard. I know it's none of you because you're all reasonable and you participate in Friday with Fran. You're all wonderful people, and I'm glad to have you. But there are sometimes board members who are like, no, it says residential purposes, no commercial activity. I don't care. I heard that he stays up at night and does day trading and after hours trading, and he's making big money sitting in his unit there. And the answer is, who cares? Why do we care? There is no impact. There is no impact on your community, right? And all you're going to do is waste a bunch of money on lawyers running around in circles and winding up in front of some judge that's going to say the same thing that I just said. Who cares? Why are you here, Mr. McGovern? Because the judges are going to look at the community impact standard. And that goes back to the classic Thanasoulis case that says the board's business judgment rule in enforcing restrictions will apply, but the judge will apply a reasonableness test. Many judges won't admit that, but they will apply a reasonableness test. So anytime a judge looks at a residential restriction and applies a reasonableness test, she or he is not going to strike that use if there is not a significant impact. Now we have some associations. The next bullet point is anything goes. The anything goes test. I don't know of a single community that has an anything goes provision, right? Every set, I should say almost every set, I guess, of governing documents I've seen, whether it's a master deed or declaration, says either residential purposes only unless otherwise permitted by the board, or no commercial use of the residential units. Anything goes, I believe, would be a disaster for our communities. The reason I say that is what we're seeing right now is a creep beyond the community impact standard, beyond the reasonable community impact standard. And I'll just give you an example, and this is, let's see. Actually, I'm not going to show it up because it's an ongoing case. But we have a case, we're involved in the middle of a case right now where, so you know this, office space is not worth much at the moment, right? Many people are working from home. Many companies have given up their office spaces, et cetera, right? So people are working from home. Those people that use commercial vehicles as part of their day-to-day job are now taking them home, right? And they're being parked in driveways, parking spots, behind dumpsters, et cetera. The picture I was going to show you, but I don't want to show you because it's going to wind up in litigation, is it's a beautiful truck that's worth in excess of $250,000, but it's a bucket truck that has signage and labeling and all kinds of stuff all over. You know, with the extending arm, et cetera, the articulating arm. And oddly enough, there are several board members who say, yeah, so what? It's all good. That's a problem because, and all of you know this, but I think your other board members who aren't on the call need to know this, that the restriction must be applied in an even-handed way. So you can't say, hey, sir, your bucket truck is beautiful and well-kept and we really like it. You can keep it. Because the next guy next door who comes down and sees that bucket truck, he's going to say, hey, that's awesome. I have a bucket truck too. It's not as pretty as his, but I'm putting my bucket truck right next to his. And you're not going to stop me, right? Because restrictions enforcement has to be even-handed. So the anything goes is a loser. And people have heard me say this before. Sometimes people get offended by it. I believe that one of the roles of the association is to avoid ghettos in high density housing situations, right? Avoiding ghettos in high density housing situations. When you have high density housing situations, which is wonderful, it allows for affordable housing. It allows for people to purchase very nice homes without having huge parcels of ground and therefore be able to live in a nice house at an affordable rate. But if you have no rule and regulation enforcement, it will quickly turn into a ghetto and it will drive the values of the home into the basement, and it will hurt the life of the residents there. So the anything goes, it's a message to, again, not your board members, you're here today, you're with us, but to the board members out there perhaps who aren't paying attention and they're like, hey, you know, what's the big deal? You know, Bob's working from home, it's fine that his bucket truck's here. The anything goes approach just is a spiral, right? Because again, it must be applied even-handedly. I wanted to make a couple more things. We have numerous people now going down the road of my office is closed or I've been directed to work from home and I therefore have to have my commercial vehicle on site. Why are so many people so ardent about that? The reason they're so ardent about it is often the company's insurance policy on the commercial vehicle will specify that the vehicle and the tools must be in the possession of the employee. Otherwise, the insurance will not cover the tools and equipment on the vehicle if something were to happen, if it would be stolen or damaged. So employees maybe won't tell you this, but they'll really, really strongly want it in their driveway because in fact, they can't put it elsewhere, right? They actually can't put it elsewhere. And again, this is one of the arguments that's made in the case I'm involved with right now. But the problem is that's not the association's issue, right? That's not the association's issue. The association's not obligated to store your bucket truck just because your insurance policy doesn't provide coverage if it's outside of your custody. Does that make sense? And some board members I've worked with have said, well, Fran, he has no option. Well, no, he's got plenty of options. His company can do what companies should do, which is provide an adequate yard for their equipment and trucks. The association is not obligated to store the equipment and trucks. So that's that real quick right now. Where are some other issues that are kind of cutting edge? Some associations have tried to back into an elimination of things like VRBO through the no commercial use argument. It hasn't been addressed squarely in New Jersey, but I don't think it's going to fly. I think if you're going to limit things like the ability to rent or the extension of lease terms or the requirement of minimum lease terms, you're going to have a separate amendment if it's not already in the documents. There have been some associations in other states who have said, hey, wait a second. Yeah, we don't have a rental restriction, but we do have a restriction that says no commercial use. And when it says no commercial use, using it pursuant to VRBO is a commercial use, and therefore it's prohibited. And the court said, not so fast. It's being used for residential purposes still. And if you want to go out and prohibit that, you're going to have an amendment as to how it's being used in the residential context. That was really quick. It's 20 after 4. Mike, do you want to say a few words about the legislation that's out there?
Yeah, sure. Thanks, Fran. So there is this legislation that's been out there since I think before I started practicing law 15 years ago in the condo association field. Yeah, it's 15 years. It's crazy. So it's the Ukiah bill, which is like the Uniform Common Interest Community Association Act or something like that. It's been around forever, and there's been variations of it for a long time. So somebody had asked me recently about it and where it stands. So I did a little research, and turns out that this bill was introduced on, get this for timing, March 16th, 2020. And if you recall, that's the day New Jersey shut down from the pandemic. So the bill was introduced on the day the Jersey shuts down. And then it sits for a year plus to June of this year. And then it passes the Senate, and then it passes the Assembly. And shockingly, it's introduced by 2 Democrats, Troy Singleton and Herb Conaway. It passes, and now it goes to the governor's desk and sits there from June of 2021 until 3 days ago, when he just absolute vetoed it. And what that means is that in order for this to pass, you would need a 2/3 supermajority in both the Senate and the Assembly to override the veto. And just so you know, the Ukiah bill kind of took the Condo Association Act, the Condo Act, the Planned Real Estate Development Full Disclosure Act, all the acts relating to community association housing, and tried to cram it into one big overarching law. It tried to fill some cracks in the laws that were there. Of importance, there were a couple provisions in there which I thought were kind of strange. And I'm only bringing this up because this has been introduced year after year after year for the past 15 years. So I assume it's not going to go away. There's a provision in this bill which provides authority for an owner to modify their unit as they see fit without board approval, as long as it doesn't impair the structural integrity of the building, as well as allows them to purchase the next unit next to them, knock down the wall, and create a larger unit without board approval, as long as it doesn't impact the structural integrity of the building. I think it was probably included in the bill to address, like, Jersey City, Gold Coast. Somebody buys a couple of units and makes a really big penthouse unit. But you can imagine the implications around the state if somebody were to buy a couple of units and turn it into more of something it wasn't originally intended for, whether it's recreational purposes, religious purposes, a large gathering room or hall. you could imagine how that could become problematic, or at least can cause issues in various communities. So those are like really the issues that I found to be the most problematic in the bill. Otherwise, it fills a lot of gaps. It's really not that exciting, but be that as it may, it was just vetoed by the governor. So as it stands now, it's no longer an issue. But come 2022, I'm sure we'll see it reintroduced again.
All right, thanks, Mike. We have some questions. We're going to try and jam right through them because I'm sure everyone wants to get home and start prepping for Thanksgiving, right? We got Thanksgiving on the horizon. I saw some people frown right there. They're like, oh my God, really? Yes, Virginia, Thanksgiving's coming. Sorry. Anyway, does it make any difference if working from home as an employee as opposed to running your own business out of the home? No, I don't think it makes a difference in terms of whether it's an employee or a business owner, at least from an association restrictive covenant standpoint. It's really going to matter what the community impact will be in terms of those factors I talked about before. I'll take the next one, and it's just Jim Maggie just made a nice comment, which is association living isn't for everyone, right? I mean, and that's true, and that's not being mean. That's just is what it is. I mean, if you have a fleet of trucks and they're bucket trucks and this and that, God bless you. We need people to do those things. We need people in those businesses, but having that jammed into a driveway in a townhome community is not the right thing. That's all. Nobody's hating you. We just it just doesn't work. Mike, you want to take the next one? Thanks, Jim.
Yeah, let me just take a look here, Fran. COVID question: can an HOA require either vaccination or recent COVID test for events in a clubhouse? Thanks. I believe the answer there would be we can. In fact, for the first time, coming across communities now requiring proof of vaccination to attend clubhouse functions. Remember, we've talked about this a lot in the past year and a half. If we're going to require proof of vaccination, keep in mind there are two exceptions that will need to be made, and this applies pretty much across the board for any whenever you need to provide proof of vaccination. There's an exception for religious purposes, right? If your religion does not permit it, and also a medical exception if your doctor has indicated that for one reason or another you should not be vaccinated, and you can provide proof of that. But otherwise, yes, community associations would be permitted to do that.
Okay, there's a note from David that says, hey, New Jersey LAC requests support in getting the COVID tort immunity extended for another year. So that's a great reminder, David. Thank you so much for highlighting that. So for those of you who don't know, I think you all do because all your faces are pretty familiar right now. So the association legislation was passed that sunsets at the end of this year. It sunsets by its own terms, which is the immunity as to COVID-19 for associations. The problem is it sunsets automatically, and CAI-LAC, the Legislative Action Committee, is working hard to get that extended. And I would say that's a very, very necessary thing, right? Very, very necessary thing. And to David's comment, I would strongly encourage everyone to reach out to their Assembly people and Senate people and encourage them to move things along and get that extended. I don't know technically how it would go. Perhaps they could just do an amendment that strikes the sunset provision or extends the sunsetting provision. I don't know. I don't know if it has to go. I'm not enough of a legislative wonk to know whether it has to be a whole new piece of legislation that works its way through the sausage grinder. But perhaps so. But hopefully people will reach out to their legislative representatives in the governor's office and make this happen. As you know, back in a year and a half ago, the governor was very much hesitant on this issue, but there's no reason in my mind that the governor and the legislator should have any hesitation at this point, especially when we have so many people vaccinated. So please support the LAC in that effort. Can an association master deed legally ban non-commercial pickup trucks such as a Ford F-150? So this goes back to the Thanasoulas case, which, although the courts don't like to admit it, they like reasonableness, which means a rational basis. a rational basis for your rules, regulations, and restrictions. So is there a reason? Is there a reason? Is the vehicle too long and it hangs over the sidewalk? Does it impair something? Is it too wide? Are the parking spots not appropriate for an F-150? And it has to be even-handed in its application. So if boards were to say we're prohibiting Ford F-150s because we really like a different brand of pickup truck, that's going to be thrown out, right? So it's you could do it. I just don't see a rational basis for that type of rule and regulation at this point. And in a lawsuit involving something like that, the claim would be that the board was acting unreasonably, arbitrarily, and capriciously in enforcing that type of rule or regulation. Mike, you want to take the next one? Yeah, go
Well,
ahead.
just a quick comment on that. So I had a family member that resided in a senior community of 55, an older community in New Jersey that had that particular rule. And he did have a Ford F-150, in fact, when they moved in. And,
Wow.
you are permitted to own it and you can park inside the garage if you can squeeze it in there. But the rule was you cannot leave it on the street or in the driveway. And their reasoning was aesthetic, right? Whatever, for one reason or another, we're not a community that wants to see pickup trucks, right? So it was never challenged. And I was always curious to see whether or not a court would actually enforce that. But I mean, they are out there. I do know of one other community that has that particular rule as well.
Yeah, that's not a case that I would like to be in front of a judge on. But I think you'd be spending a lot of money for a loss. But be that as it may, some associations have them out there until they're challenged and perhaps will back down. I know a number of associations in Florida. The claim is they prohibit motorcycles on all of their roadways because the claim is that it increases their insurance rates. I can't imagine that that's borne out statistically, but I have a friend in Florida who had to store his motorcycle off-site because he didn't want to fight the litigation over the banning of his motorcycle. So, be cautious. You don't want to go down the road of arbitrary and capricious. You have to have a rational basis for the rules and regulation that you're passing or enforcing. Mike, you gave Danielle. Hey, Danielle.
Danielle asked for the bill number, so that's for the Ukiah bill, and
Okay.
so again, that did pass both houses, but again was vetoed by the governor.
Right. Any feeling on when it might be acceptable to allow guests to attend association events or be in the clubhouse? That is a judgment call with management and the board and the various clubs. In terms of this, so the question is allowing guests. It's a judgment call, and I would say if you're going to start allowing guests, that you manage it very carefully, because my experience is especially with active adult communities that more often than not the events are oversubscribed, right? The events are oversubscribed, and when residents are bounced from limited subscription events in lieu of guests, it becomes a very difficult thing for the association to rationalize, right? Because you're probably limiting your numbers right now just to be a little extra careful in the COVID context. So I think it's a judgment call.
And Fran,
Mike, you want to take the next one?
Yeah, I just had a community that's talking about renting out their clubhouse to outside, people that don't live in the community. I think that's pushing the envelope, but make sure that you should have your statutory immunity signs, right? The association won't be held liable. The signs, we can send them to you if you don't have them. You want to print them out, put them on the clubhouse door and inside the clubhouse. And you can also, which I would suggest as well, have the residents or anybody using the clubhouse sign a release waiver agreement.
Okay. Do you want to take the next one, or Mike, we take it together, the clubhouse?
Sure. Is the clubhouse considered commercial versus residential? The clubhouse does house any businesses.
Okay, and it goes on to say the question on the clubhouse deals with warranty issues on windows in the clubhouse. So that's really, really specific, Ed. We'd have to talk about that more. I would say that in most associations, the clubhouse is not considered commercial. It's an amenity that pertains to the residential use of the members. There are a number of associations that we work with that do, however, have bank branches in their clubhouse or an extension of the clubhouse or other commercial insurance agents or what have you in the clubhouse area or attached to the clubhouse. Now, they would be commercial. As far as the window warranties themselves, I think you'd have to look at the particular models of the windows and see actually how the warranty applies and which warranty applies. Commercial will be used in different contexts. And the worst words you ever want to hear, because as a kid growing up, I always thought that the words builder's grade meant, oh, that's the best, that's the really strong stuff. And then I got into this industry and I learned that means linoleum. you get the linoleum, Mr. McGovern. But so anyway, yeah, Ed, you're going to have to really take a look at that in terms of specifics. If you want to talk about it offline, we can. If we require vaccination, what's happened if a resident says they don't want to comply? Well, so I think if they don't want to comply, other than the exceptions that Mike just articulated for healthcare reasons or religious reasons, then they're not going to be able to participate. If that's a judgment call by the board, I can't. Again, for those of you who've been on these calls with us for quite a while, there was a time where we thought, government may really beat us up if we go down the vaccination road. Government may really spank us if we get involved in that, because I don't know what's the scope of authority. At the moment, and I could be wrong, I can't see many judges right now saying it would be unreasonable, especially in an age-restricted community, to require vaccinations for events. And I'm not trying to take a political position. I'm just trying to give my feedback that the tide seems to be at the moment that government writ large wants the momentum to encourage people very much so to get vaccinated. So I don't see an association getting spanked for that right now, but I have been proven wrong before. I really believe all these judges should agree with me, but they don't always agree with me, which is so annoying at times. Anyway, is the clubhouse considered private or public? Sorry for the similarity to the above question. So the clubhouse is private. Clubhouse is private unless it's not. Unless it's not. That's a lawyer answer, right? So a clubhouse is a private amenity, right? But you can make yourself kind of quasi-public by opening yourself to the public. So there are many associations, because of financial considerations, where they had a totally 100% private golf course, for example, and a totally 100% private pro shop that was only used by members and guests. But now what they're doing is they're selling memberships to the public to use the association's facilities, things like the clubhouse, things like the gym, things like and I don't encourage this, but I think some associations, especially certain golf associations, have found themselves not able to fund golf appropriately. The problem with doing that is you don't make the property itself public property, but by opening it to the public, you may be making, and probably will be making, your facilities that are open that way subject to various laws like the ADA, not just the Fair Housing Act, the ADA. Things like the barrier-free subcode may be more applicable to you and may be more stringently applied. You see what I'm saying? So they would not consider your property public, but they would make various laws apply to you as if it was a public facility. So as if it was a Wawa, as if it was a post office. So you have to be very careful with that. I haven't seen it recently, but maybe 10 years ago, for those of you who are around that time in the industry, there were testers going around under the ADA, where they would go around with a person in a wheelchair, a lawyer, and an engineer, and they would go to any association facilities that were open to the public, and they would test them, if you will. And if the association refused to make the modifications that they demanded, they would sue the association based on ADA complaints. And the ADA is a fee shifting statute, which means if a plaintiff sues the association successfully, not only do you pay your attorney fees in defending the case, you pay the winner's attorney fees too. So it was really annoying because they went after two of our associations. We got the cases settled pretty promptly, but it was a little scary at first. Sorry to end on that note. Can somebody give me a happy note to end on?
Hey, Fran, somebody asked a good question here directly to me. It said, what about, this is the statutory immunity. What about if the event is scheduled for New Year's Eve? The immunity would no longer be in effect that night, correct? So the immunity currently, the statutory immunity for COVID ends on the 31st at midnight, right? So that presents a bit of a quandary if you're going to hold a New Year's party in your clubhouse. Yeah, that's a problem. So hopefully this gets rectified between now and the end of the year.
Yep. So that being said, does any other questions? Anything we missed? I think that was kept it nice and brief today. Yeah, from the LAC chair, they say get everyone out by midnight. So I guess so. You could do that, but that doesn't sound like much fun. Okay, so well, I hope everyone has a great Thanksgiving. I hope that this year, as opposed to last year, people are able to hug it out and see family members in person and do all kinds of good stuff like that, other than sitting on Zoom calls with their grandchildren and children and et cetera. And I hope you have a great holiday, and it is great to see everyone. Have a great weekend.